with the demands. And that has been really an ongoing problem in Lake County. And I think the hope is maybe this is a possibility. Maybe we find out it's not. Maybe this won't solve our problems. But I think it's worth having the discussion to see if it is a tool that might be viable, that could accomplish those purposes. So before we jump into our presentation, do any other commissioners want to sort of weigh in on your thoughts and the reason that we're here today and what you hope to get out of this workshop?
Well, I'm not 100% in tune to what a charter county is, and I'm hoping this will give me a lot of insight on what a charter county is, along with our citizens out there. But I have to agree with the chairwoman that, we've been fighting for the last 5 or 6 years to have the cities coordinate with the counties to help us at least control the growth in a smart way and help our infrastructure. So hopefully this will be something we can look at.
Commissioner Marks.
Yeah, first of all, just want to welcome everybody. I appreciate the opportunity, and Chair, thank you for organizing this. I think not just today, but throughout this whole month, these are some very good issues, some good things for us to start talking about as it relates to growth management. And I just want to let all the cities know, appreciate you being here today, and I hope you're going to be a part of this whole series with us. I'm here to listen, to learn more about what Charter County could be today, but really want to encourage the cities and residents that are here as well that are concerned about this issue to follow these workshops that we have throughout this month, and not just this month, but maybe the rest of this year, because what we really want to do, and I think we're all natives to Central Florida for sure, at least Lake County, most of us. I mean, we're sitting in the same traffic that you are. We're concerned about the loss of open space, the loss of agricultural lands, all that kind of stuff. So it's not lost on us. And I think today is probably informative, but more informational. But this whole series is about how can we work with you for better outcomes and addressing growth management. And that's really what this is all about. Looking at reduction of duplication of services, perhaps. Just a better outcome for our residents, because what we're doing now we know is just not working, and we're trying to fight this, but we got to do this together. So I'm appreciative of this moment and just ready to listen today and learn more about Charter County.
I agree with my fellow commissioners and just want to thank everybody who came out here today. Thank you very much.
Well, growth's not a new issue for Lake County. It's been a long time. I was fortunate enough to serve on planning and zoning for 18 years. So I might have been part of the problem, but I'm going to be a part of the resolution now. I want to thank the counties, or the cities, for coming out and hearing about charter. We've kicked the can down the road too long. We can't fix everything overnight, but I think we have 14 municipalities with governments that they have smart people sitting on, that we can all come up with a solution. And it might not be an overnight solution, but I can guarantee you we can come up with a solution. And thank y'all for being here.
All right. Well, thank you, everybody. And again, much appreciation for taking the time to be here. And this is really about hopefully having some good dialogue and learning a lot today, and then seeing where it takes us. So without further ado, our presentation today will be given by Ginger Delagal, Executive Director of the Florida Association of Counties. And we appreciate you traveling to be with us today.
Thank you, Madam Chairman. It's absolutely my pleasure to be here. My favorite days in my current position are the days that I can be out and in the counties. And certainly things are a little tense right now in the Capital County with all of the budget discussions going on. So even having another excuse to be out and to be able to do what I love to do out in the counties, it's my pleasure to be here. And I want to say thank you for giving not only me, but the Florida Association of Counties the opportunity to come and spend a little bit of time with you this afternoon on a really important issue. And then just on a very selfish and personal note, I do want to commend you for putting together this series of workshops that you all are doing with your community. And by selfish, I mean my husband and I have 3 daughters. They are all grown. We want them to always find Florida as a place where they can live out their entire life. They were born here, educated here. We've only got one who's left at the moment, but she's promising that this is just a little thing, flirting that she's doing with New England, and is coming home in 2 or 3 years. So we're going to make sure that happens. So selfishly, thank you for taking this opportunity with your community here in Lake to have these, challenging conversations. They are important as a state and as a community as you continue to move forward. So thank you for doing that, again, in a very selfish way. Just a couple of things of introduction to the Florida Association of Counties. We are a not-for-profit private corporation. All counties in the state of Florida voluntarily join every year. So we have to earn, all 67 counties, your trust and that you find value in being a part of the association every year. There is nothing mandatory about it. It is your choice to choose to come out and be a member of the association. Lake is obviously a very long, deep, and wide member, very active within the organization, and for that we absolutely thank you. We also have an educational foundation that is a 501c3 that is our education, training, data, and research arm. And so we come to you not only as public policy folks in county government in that space in the state of Florida, but also with a background in training and education. And so again, this is a great opportunity for us to be able to show you and your community why, in fact, you are a member of the association. As a nonprofit, you all know you serve on local nonprofit boards. We're mission driven. That mission is intended to help you all govern effectively and efficiently back here through advocacy, through collaboration, and through education as well. So thank you for that opportunity today. A little bit about me. I always think it's important that you know who it is that is talking to you. I am pretty transparent of telling you what my biases might be in this area. But a little bit about me. I am a lawyer by trade. Started out with the firm almost 35 years ago now, with the firm of Neighbors, Giblin, and Nickerson, all local government here, all local government law in the state of Florida. Spent 10 years with them doing finance and tax work all around the state of Florida. So my courtroom, if you will, were county commission chambers as well as city council chambers all around the state of Florida. Came over to the association as general counsel. This was the 3 to 5 year career plan. 20 plus years later, I am still with the organization and was asked in 2017 to step up and serve as executive director. So a little bit about me. I've got 3 daughters. My husband is also a lawyer lobbyist, so we have very interesting conversations. Our children have not chosen politics or public policy, however, which makes us a little sad because it is what we've always talked about around the kitchen table. All right, switching to today. High-level overview on charter government in the state of Florida. Yes, we will get into some of the details whenever we get into the back part of the conversation, but I like to start with what I call the what-fors. So we're going to do some basics so that there is level setting among all of you and among other community members that are either here today or may actually be able to watch or listen later on, so that everyone is speaking the same language as you continue to have these conversations. And so we will start with some pretty basic information about what a county is in the state of Florida, because there are some significant differences here than in other states, well, actually most other states around the country. And then we'll get into what it means to be a charter form of county government in Florida, et cetera. We will talk about some of the high-level differences between a charter and a non-charter county. We will talk about some of the subject matters that can be addressed, as well as public policy decisions that can be included in a charter, and then we will wrap things up at the end talking about what the steps are to actually adopting a charter for your county, and then also how you change it, how you amend it out into the future, because it is a local constitution that lives and breathes as your community also changes. So it's important to understand how those changes become effective into the future. So way back in 1821, the state of Florida established a provisional state government that established a county judicial system, appointed county judges, clerks, and sheriffs. And the county government around the state at the time was administered through a court system by 5 justices of the peace. Doesn't sound a whole lot different, does it, than what you actually have today in terms of there being 5 of you all. There are some county judges. You still have clerks. You still have sheriffs, all of whom are coming together under the umbrella of county government even today. So in some ways, a lot hasn't changed, although a lot also has. So what is a county as contrasted with a municipality or a special district? And we're going to get into some nuances here that become very important when you're talking about a charter for a county in Florida. At its most basic form, a county is a political subdivision of the state established by the state to execute state services and functions at the local level. It's a mouthful. The point is, sort of in the beginning, counties were lines drawn on a map for service delivery purposes from the state. So for example, today, if you want a flu shot, you don't go into the Department of Health, their main office is in Tallahassee. Where do you go to get a flu shot? You go to the joint, generally speaking, public health unit that's run by the county, and then the state still has a role in it as well. But it is a service that is delivered locally on a more regionalized basis out of the state capital. There were not a lot of political powers that came with those lines being drawn on the map originally for a county. They were literally regions through which the state services were intended to be delivered. That's obviously changed over time, and we'll talk about that evolution in the state of Florida. But it was a top-down structure created by the legislature for the delivery originally of state services at the local level. You contrast that with a municipality that is, like a county, a general purpose local government that serves its citizens who created it by charter. It is a bottom-up local governmental entity, meaning it starts with citizens joining their voices together to act in a more consolidated area to ask for additional either services, programs, or something that is different. Yes, it ultimately goes through a legislative process, but it starts organically at the local level and works its way up in terms of creating a municipality. County is top down, municipality is bottom up. We've got tension, however, in Florida because we're a great state. So things can't always be so simple and straightforward. In Florida, because of really the demographics and the growth, not only high growth of population over most of the 20th century, now into the 21st century, but also the patterns of that growth has created the following. So even today, it's almost 50-50 of the amount of the population of the 3rd largest state in the country, where there's over 400 municipalities that live in unincorporated areas of the state of Florida. And most of those folks have generally come from somewhere else, and they are used to being able to turn to their local government for more municipal-like services because they're coming from a town culture, they're coming from a village culture, they're coming from a municipality, and they're coming to Florida but living in the unincorporated areas and turning to the county and to the county commission for more municipal-like functions. And so you see now in Florida, counties in economic development, counties in tourist development, counties in workforce development, counties in affordable housing, counties in additional law enforcement and police services, counties in urban infill issues, counties in growth management. Generally speaking, around the country, those have been thought of as municipal functions. But that isn't the case in Florida, partly because of demographics, partly because of constitutional changes in 1968 that we'll talk about. So those two things combined mean that counties in Florida operate generally much more like municipalities in other parts of the country, in addition to all of the other state-mandated functions and roles and responsibilities that you have. And that leads to tension at the local government level with other governmental entities that are in your county. And we have lots of counties in the state that have as many municipalities as you all do here. And yes, there's conflict and there's tension with overlapping services, with overlapping program, with overlapping decision-making for the entirety of your area. Normal, very normal. Take a county and a municipality, and then you contrast it with a special district. And a special district is also a local government created by another level of government. So either the county commission has created a dependent special district for flood control, fire control, what have you, any sort of service like that, or a municipality has created it, or it's been created by the state legislature. So created by another level of government for a single purpose. So that's why I give you those examples. They're not in the general governmental service business. They exist for a sole reason, either a sole program or a sole service in a very defined geographic area. All right. The forms of county government, and then we're going to start picking up the pace here. There are 3 forms of county government in the state of Florida that are still operational. County commission form, the commission county administrator form, and the commission elected executive form, which is in fact only available to charter counties. Let's talk about this commission form, not because you are one, you're not. You're the commission administrator form, but I do think it is helpful to show, again, the evolution and to understand the distinctions between these 3. So this is the one that's been around really since the late 1800s in the state of Florida. And if you think back to ever hearing phrases like a county commission having a commissioner of agriculture and a commissioner of road and bridges and a commissioner of flood control, they would then come together as the county commission, having been elected in those subject matter areas, if you will, to then govern the entirety of the county itself. The big thing with the commission form of government is that both those policy decisions as well as the execution of them all lie with the county commission. Easy way to think about this is we still have about 5 counties in the state that don't have a professional county administrator at all. They run the county through the county commission. And this harkens back to the 1800s bringing that form of government forward. So no single person in these counties is responsible for the administration of the county functions, and the various county department heads each report directly to the county commission. So what you have is the clerk, the sheriff, the property appraiser, the county commission, supervisor of elections, and the tax collector, all comprising county government. You generally have a county attorney that reports directly to the BOCC, but then the individual department heads also report directly to the BOCC, which is not what you all have right now, and almost every other county in the state doesn't either. But keep that picture a little bit in mind. At the very other end of the spectrum is the executive form of government. This is a charter county option only. We'll come back to this one a little bit later. Right now, we only have 3 counties in the state of Florida that have this form: Miami-Dade, Orange, and Jacksonville-Duval. It completely separates the legislative function, so the Board of County Commissioners, from the execution of the policy that you all establish. But the person that is responsible for carrying out your instructions is an elected executive. So an elected officer countywide is, in fact, serves in the same function as the county administrator. You will often find professional staff, in fact, you do in all three of those counties that I have mentioned, that support that elected executive, but that person is, in fact, the person and the office that carries out the legislative direction and the policy direction of the county commission there. There are a host of powers that can go with that. They can have an equal vote or not. Many of them actually have veto authority, however, of ordinances that are enacted by the county commission. Again, it's a charter only, so we only even have 3 of those here in the state of Florida. There are other states around the country that this is a very popular form of county government, but it's not ever really taken hold much here in Florida. All right, so that leaves us with around 57 commissioned administrator forms of government. Clearly the most popular one in Florida today, the key difference being the separation of powers between making policy and executing policy. And you all know this all starts by the county commission enacting an ordinance establishing this form of government for your county, giving the county administrator certain authorities and power. And often this is also joined with a non-interference ordinance where you all, as the county commission, deal directly with the county administrator. You hold the county administrator accountable, but the county administrator has the authority to hire and fire all of the county staff. It's a non-interference. You all stay on the legislative side is what that is. So it's a separation of power, if you will, sort of in a constitutional sense. So if you look at a very basic chart, this obviously looks different than the commission form where you have only the county attorney and the county administrator reporting directly to the county commission. So which one of these fits? Population is a big driver. You can probably already guess that those literal handful of counties that are still a commission form are our smallest of the smalls. The reason for that is you've got a fairly similar population makeup still in those small rural counties that have that form of government. They've got a lower expectation for services and programs than what you're going to find from your community here in Lake. And there's very little political conflict among the citizenry. So they tend to be of like mind. So you don't have a lot of outside influences that have come into those communities yet, bringing with them some different ideas. And so you really have folks sort of on, from a mindset perspective and a community perspective of what they're expecting, they're on a very similar playing field. But with population growth and diversification, there is more conflict that is inevitable as well. The demand for services and programs increases with your population, and just efficiency for government really needing a single individual that is in fact carrying out the policies that you all have established. And so we start to see into the 20th century a transition from that commission form of government now mainly to the commission administrator form. When I started at the association 20 years ago, we had 12 counties that still were that commission form. And so just in the last 20 years, we've moved 7 of those to the same form of government that you all have here. And then obviously the other county officers make up county government: the property appraiser, the tax collector, the clerk of court, the sheriffs, and the supervisor of elections. All right, so that's the county. What is home rule, though? How do you operate? What is the authorization for you all to be able to govern? And in Florida now, since 1968, we are in a home rule state. And I know you hear that a lot. What does it mean? It means that you all have been granted by the Constitution and the Florida legislature the tools to govern without needing outside approval unless there is conflicting law. And so you all have heard the term preemptions, and that is the label that is placed on those state laws that then create conflicts with ordinances you may have. And it isn't that they weren't authorized or lawful when you enacted them because you did them under home rule. It's that the legislature has now stepped in and said, we want a different path for the state of Florida, and we're going to take everybody with us down a different path. And then it becomes conflicting and an issue that you have to deal with. One of the things here is that it is a transfer from the state to local elected officials the authority to govern at the local level. A part of this came about in the 1960s because of population growth, because of the diversity of population, but there was also really a third reason. And because of the population growth, though, there was the need for some legislative efficiency. What do I mean? Pre-1968, I use this example. It's oversimplified, I realize that. But as an oversimplified example, let's say you had a vacancy in what now we would call the animal control officer, right? Then it would have been the dog catcher. So vacancy in the dog catcher position, that person in 1962 was making $25,000 a year. You wanted to get a brand new graduate out of the University of Florida vet school, but that person was going to demand a $28,000 salary. You would have had to have gone to Tallahassee in the form generally then of a special act to get authorization to raise the salary of your employee from $25,000 to $28,000. There were thousands of these filed in every legislative session. And very quickly after the 1968 constitutional change, they dropped to about 200. So just from a legislative efficiency standpoint, the effort of trying to govern every municipality and every county through the state legislature, even in the 1960s, because of the growth and the diversification, was just, it came to a halt. Meaning government came to a halt to try to govern at that micro level. And so that was a huge driver also of the home rule amendments actually being placed on the ballot, was to seek legislative efficiency. Now, these ideas of being able to govern for your community and based on your community's interests and priorities and the resources that the community gives you to govern, these are obviously, notions of independence and of freedom and of voice and of participating. And these are generally thought of ideals of self-governance that we hold in high regard here in the United States. So home rule is very consistent with that, but it also leads to a lot of tension, not only within the local community, but with the state government, and you know that. And so some of the words that get used in the labels are preemptions, they are unfunded mandates. This is not a unique Florida situation. These conflicts in those other home rule states around the country exist also. It is the nature of intergovernmental relations. You're not always going to agree with your other governmental partners. And so out of that conflict of ideas at times will come an unfunded mandate or a preemption whenever we are having those discussions, if you will, with the state government. All right. I want to talk about one point. And yes, I am quoting the Constitution for the next couple of slides here. I'm going to wrap it up, though, with what it is that I'm talking about. So let's start talking about how home rule in a charter county starts to be different from what you all are experiencing today as a non-charter county, all right? So you start with the Constitution, and there is constitutional language that charter counties shall have all powers of local self-government not inconsistent with general law or with special law approved by the voters. The charter shall provide which shall prevail in the event of conflict between city and municipal ordinances. All right, put a pin in both of those phrases that are bolded. We're going to come back to both of them. The provision in the Constitution for non-charter counties says they shall have such power of self-government as is provided by general or special law, blah, blah, blah. But an ordinance in conflict with a municipal ordinance shall not be effective within the municipality to the extent of the conflict, which is what you all are experiencing now as a non-charter county. So Sandy Dallenbert, who was the official commentary to the 1968 constitutional revision, in looking at those provisions that I have just quoted for you, here's what he said. Thus, charter counties and non-charter counties apparently start from different poles in their relationships with legislative enactments. Both could, so both a charter and a non-charter county could conceivably be the same, depending on the legislation adopted. So what did the legislature do? 1971, they come back and they enact very broad language. Legislative and governing body of a county shall have the power to carry on county government. Sounds a lot like that first quote I gave you on charter counties, right? To the extent not inconsistent with general or special law, this power includes, and then they go on to enumerate close to 35, 36, or 37 different powers in addition to home rule that you have. The enumeration, so articulating those 35 things here, is not exclusive or restrictive, but is deemed to incorporate all implied powers necessary or incident to carrying out such powers enumerated. Then they go on, and then they finally say, this section is intended to secure for the counties the broad exercise of home rule powers authorized by the state constitution. All right, here's the wrap up. So I'm going to take these pearls and put them all together for you. The home rule power of a charter county is implemented directly from the Constitution. There was no intervening legislative act that has to take place for a charter county to have all powers of local self-government. It comes straight from the Constitution, which means it comes straight from the people of Florida. A non-charter county sits with incredible home rule authority, but a non-charter county needed the legislature to come in and grant it the home rule authority. That's the difference between the two. So there's this intervening where the people of Florida in a non-charter county situation set up the opportunity for home rule, but left the final decision to the legislature. With respect to a charter county, it is granted to you automatically without legislative intervention. That's the difference. Okay, so what is a charter county? Well, there really isn't an official definition. So here's the most basic one I could develop. It's a county. You start with that, whose citizens have approved a local charter. So now you should be thinking municipal-like, okay? Local charter means you all have come together as a community from the ground up and made some decisions about your county that are not top-down. They're more ground up. Granting the county government home rule authority directly from the Florida Constitution. Here they are right now in the state of Florida. We have 20. Obviously, you can see the highly populated southeastern 3 counties of the state. You can see some in the mid-southwest area. The I-4 corridor is pretty blanketed from east to west. You've got some up in the northeast. And then once you hit that junction at I-75 and I-10 in Columbia County going west, you've only got 2. So you've got the entirety of the panhandle with only 2 counties there that are charter. All right, when did these counties become charter? Starts back in 1957, which, yes, predates the 1968 Constitution. Miami-Dade actually had some particular provisions in the Constitution that date way back, even before 1957, authorizing it to create itself as a charter form of government. So you go back to 1957, and then you start to move forward. And the most recent one is still a pretty good ways back, and that's Wakulla. So a small rural county that actually became a charter county. The issues in all of these counties in becoming charter are as unique to those counties as those counties are unique unto themselves, meaning the issues at the time were different and the issues by location were different. Just by way of high level, what you see, yes, in the high metro area, so Miami-Dade, Jacksonville, Duval obviously became a consolidated government. It's the only one that we have in the state of Florida. Highly urbanized, issues at stake there. Then you had a series of issues that related to the relationship between the county commission and the constitutional officers, because prior to 2018, a charter county could actually alter the functions and duties of the constitutional officers all the way up to abolishing those offices and then making them just a department of the BOCC. It's no longer an authorized choice that you all have after our constitutional amendment in 2018, but up to that point, you could go all the way and even abolish some of those offices. That was at issue for a fair number of years. You will also see some of these counties that it is local intergovernmental issues that were the driving force. So the city-county relations that were the driving force for a community looking to a charter. And then you find some that were very citizen-driven. In 2002 and in 2008 in Wakulla, both, the citizens were seeking reform with respect to the county commission itself and with county commissioners. And so it was very much a citizen-led process, reform for individual county commission seats that were the driving forces in those counties. So a whole host of reasons. The other thing here is, even though this was authorized back in 1968 and we only have 20 in the state, it's not easy. It's not easy. My home county of Leon County, 2002, became a charter county. They had tried at least 3 times before it passed on a referendum in 2002. So it's not an easy hurdle to get over, and it takes the entire community working together. So one of the things, too, before we segue into the next little section that I do want to talk about is that, I've said it a couple of times, but I want to put a little bit of a spotlight on this one point, and that is that as a non-charter county, you do have a fair amount of home rule power already. And it can make becoming a charter in many communities, things don't look that different the day after a charter has been adopted than it did the day before. Because in Florida, you have great opportunities even as a non-charter county in the home rule space. Now, there are some tremendous differences, and we will talk about that. But a lot of counties, their initial charter is, and it's a horrible phrase, but we call it a starter charter. So a starter charter, it doesn't change very much the day after the charter is adopted than the way you all governed and functioned the day before. But there are some significant differences, and the one overarching difference, and we're going to get into some of the details, here it is. Even if the charter is what I call a starter charter and it doesn't make significant policy changes from day one, it is an opportunity for reform of county government and for your community into the future. So it is a tool that has been placed in your toolbox. The question is how you use it. That's where a lot of the discussion around a charter actually comes from. It isn't from becoming a charter, it's what is in the charter. Just like the devil is in the details, make sure you read the fine print, all of those phrases and trite statements, it applies here as well. All right, so there has to be more than one difference, right? Well, there is. So choosing your form of government is a choice that a charter can make. So we've already talked about this executive form, and I'm going to break it down for you even more discreetly in just a second. But just as an overarching difference is choosing your form of government. The power to levy certain municipal taxes in the unincorporated areas becomes an option, not an automatic, an option for a charter county in unincorporated areas. This one, no longer. The power to alter the functions of county officers. I still like to mention this one because a lot of folks are still remembering pre-2018, thinking, oh, well, we can get rid of the tax collector and just have make them a part of the budget office. And that is not an option any longer for any charter county. In fact, those charter counties that had made those choices, altering the functions and duties and or abolishing, there was a transition period. And even now Miami-Dade has their first elected sheriff that they have had in 70 years, a very long time. You have the power as a charter county to have express countywide authority. So I know you keep talking about growth management. So that would be an area that the charter could in fact address as a specifically articulated county-wide approach to growth management. There are others, and we'll talk about what some of those other examples are. But you have the opportunity to have express countywide authority. Any special acts that are enacted by the legislature in a charter county, for them to limit your authority, have to be approved by referendum. That is not the case in a non-charter county. So the same legislative act, if you happen to be a charter county, in order for it to limit your authority, would have to go on a countywide referendum going forward. Your citizen involvement in a charter county and in the charter can actually be increased over what currently exists today, and we'll talk about how that happens in a second. There are some legislative classification benefits, meaning how the legislature at times views choices that have been made by charter counties, especially if it is a particular charter provision. And again, it's because it's a bottom-up choice, that those are choices that have been made not by government, but by the citizens who live there. And there tends to be an awareness that the citizens have spoken on a particular issue, and generally will approach preemptions for charter counties in certain areas with some greater deliberation or with more of a scalpel approach to the problem that they are trying to solve. And then finally, in addition to some of these taxes, there are some other revenue sources, particularly on the rate structure. So one example is the communication services tax. Upon becoming a charter county, you would have the choice of a rate differential. There's a whole 30-year jurisprudence reason why that is available to you, but there are some increases actually in revenues that you have available as a charter county. Again, it's not automatic. It's still a choice that the county commission would have to make, and in some certain circumstances, those even have to be approved by referendum, but they are available. All right, so breaking those down even a little bit further. Talking about the forms of county government, what choices could be made in a charter. So just looking at the legislative branch, so primarily at the county commission, the choices for your districting schemes expand. Right now, as a charter county, you can either be 5 or 7, and there's a statutory process on the 7. I'm not suggesting this, so please don't mishear me, but if you wanted to go to 11, then those are choices that you have as a charter county. If you wanted to go to 9, if you wanted to make other choices, if they fit your community, A charter now grants your community the ability to make those choices into the future. The election methodology. So do you want to be partisan or nonpartisan as a community for your county commission seats going forward? Salaries of commissioners. Yes, they can be capped in a charter. Terms of office. Quite a hot button issue right now in terms of term limits for county commissioners around the state. As a charter, this one is much easier to do than it is in a non-charter county. You have the ability, your community has the ability to place terms and term limits on the offices of the county commission. In the executive branch, you choose the appointed professional administrator. Yes, you already have this form of government, but the community can embody in the charter certain prerequisites that they want that position or that person to have. If there are educational requirements, certain due process requirements on termination processes, as well as the hiring even can be embodied, certain processes in the charter itself. You can have an elected chairman. Volusia has this one, for example. So the chairman of the board is actually elected on a countywide basis, but doesn't have the powers of an elected executive. That person has the same voting rights and weight as all of the other county commissioners, but that position is elected on a countywide basis. And then obviously you have the elected executive that we've talked about in just those 3 counties. So the power to tax, what choices do you have as a charter? So the public service tax is the primary municipal tax that now as a charter county you would have the ability to levy in the unincorporated areas. It's a gross receipts tax on electric, sewer, natural gas. Not as popular, honestly, around the state as it used to be, but it's still a choice that exists as a charter county. We've talked about the higher rate potential with the communication services tax. There are expanded local options in the sales tax arena that becomes available to a classification of charter counties. There are some additional miscellaneous tax sources. They tend to be highly specific and mainly for the large urbanized areas of the state, but there are some miscellaneous tax sources that are also available to charter counties. And this one is of interest. The charter can actually limit your authority to raise revenue. So it isn't just a one-way street. Remember I said the charter is an opportunity for governmental reform. So that can go both ways on all of these issues that we're talking about, meaning you can contract or you can expand, or you can stay somewhere in the middle with all of these. And the power to raise revenue is one of those. Brevard County, for example, has a hard cap on the amount of revenue that it can raise from ad valorem taxes, or it has to go to a particular voting mechanism that they have as a part of their charter. It's not on the millage rate, but it's on it's a revenue cap. Sarasota County used to have one. They have since repealed it, but they had a similar limitation on their authority to raise taxes across the board. So taking all of their tax sources, again, it was really a revenue cap. And that one they repealed about 15-ish years ago. So you can see, yes, some people can get some angst when you talk about more taxing authority, but as a charter, there are choices for the citizens that go both ways on that one. So I just wanted to make sure that that was something that was understood and that we do have counties that have actually placed limitations on themselves. So now no county can abolish any of these offices. They can't transfer the duties. They can't change the length of office. We had counties that were placing term limits on constitutional officers, and they can't establish any other matter of electing those constitutional officers than what is in state law. So the charter choices on countywide authority. So the default is that a city ordinance continues to prevail. That is the position that you all are in as a non-charter county. We have at least half of the charter counties in the state that this is still their position. The charter indicates that municipal ordinances will continue to prevail over county ones. It's a choice that those communities have made in their charter. This is the one issue that the charter has to address, however. It's in the constitutional language. If you'll remember that I had bolded for you when I gave you the constitutional language on Charter County, that last sentence that said the charter shall indicate which shall prevail in the event of conflict, the charter has to make a choice. So you have to choose municipal ordinances, county ordinances, which ones are going to prevail. It doesn't have to be for everything, however. Not all subject matters. So we have charter counties in the state that municipal ordinances still prevail from start to finish. We have charter counties in the state that county ordinances will prevail from start to finish. And then we have charter counties in the state that have picked certain subject matter areas, saying these are the ones that the county ordinances will prevail. All others, municipal ordinances will prevail. So you can choose. Okay? Oh, and then you've got some, and this gets really tricky, that the county ordinance prevails, but the cities are permitted to have more stringent standards than the county ordinances. So you have lots of choices here in terms of that intergovernmental relationship. All right, citizen participation. So in a charter county, there can be a citizen initiative process, both for charter amendments into the future and ordinances. So citizen petition ordinances can be authorized in a charter. And the charter then chooses what the percentage of signatures are, where they need to come from, and some of the procedures related to them. And we do have a host of counties in the state that are charter that have a citizen initiative ordinance process in addition to a citizen initiative charter amendment process out into the future. Also increasing the participation for citizens in a charter county. This is automatic by operation of the Constitution, that county commissioners are then subject to recall. So again, getting to a charter county sort of meshing traditional forms and traditional thoughts of county government with municipal ideas. Municipal elected officials are subject to recall. As a charter county, so are county commissioners. All right, how do you get there? So there are a couple of different ways. A charter commission can be established in a location, and this comes about either by the county commission establishing a charter review commission, or there is in statute, there is a citizen-driven process for creating and triggering a charter review commission. And if, I think it's 15% of the electors in the county, that if that threshold is met, then the county commission doesn't have any discretion at that point except to appoint the charter review commission. Whether it's by resolution of the county commission or a citizen initiative process, a charter review process is a very time-constricted process, meaning the statutory scheme lays out from start to finish. It's about 18 months, and that's all you get for that. And then through a charter commission process as well, the final product that is presented back to the county commission doesn't have any discretion except to place that on the ballot. The county commission in both circumstances or your legislative delegation, if it is a citizen initiative process, will actually appoint the members, but no member of your legislative delegation and no member of the county commission can serve on the charter review commission itself. So while you might have the power to appoint, you cannot appoint yourselves. If it comes from the legislature, they can't appoint themselves, or any of y'all either. The ultimate work product, if you will, so the charter itself, under the Constitution, has to go before the voters in a countywide referendum in a special election. However, that special election, for efficiency purposes, it can be the same day as a primary election or as a general election. But technically, it is a special election for the charter. Same thing with amendments out into the future. So that's one way, a charter review commission. Second way that a charter makes its way to the ballot is actually a special act of the legislature. And we do have counties, and I've got a chart right after this one. I'm going to show you what the choices are of how charters, the ultimate charter that was approved, how it got approved, meaning how it started. So we do have a fair number of counties in the state that their charter originally derived from a special act by the legislature. Thirdly, an ordinance of the Board of County Commissioners can be a charter that is placed on the ballot as well. Typically, when a community chooses this ordinance process, even though there is not officially a charter review commission, there are citizen advisory groups. You remember my story about Leon County having to go 4 times on the ballot before they actually got it done? The last time, the county commission adopted an ordinance, but worked for about 2 years with citizen advisory groups on the drafting of the ordinance and ensuring that the community voice was really embodied in the charter itself. All right, so this is what we have. We've got 3 counties in the state that their original charter made its way to the ballot through a special act of the legislature: Jacksonville, Duval, Pinellas, and Volusia. You've got a whole host that started as an ordinance of the county commission, and then only one less than the ordinance is the charter review commission process that the original charter got on the ballot. Once approved, how do you change it into the future? Remember, I said it's a living, breathing document over the course of time, really like a living constitution intended to help guide your community decades into the future. Sometimes, I mean, we're getting there. We may end up, 100+ years on some of our charter counties in the state of Florida. So it's going to need amending in the future. How do you do that? So amendments can be proposed, generally speaking, by the same process: the county commission, a citizen petition drive, a charter review commission. And almost every charter county has embodied in the charter itself a regular schedule for a charter review commission, so that you already have going, every 6 years, every 8 years, whatever your choice, every 12 years, that you would convene a charter review commission. That doesn't mean that there aren't other ways, if needed, to amend the charter on a shorter time frame. But the charter is going to control how you get to amendments into the future. The most important thing to understand about amendments, though, each amendment goes on a countywide referendum at a special election as a single issue. Amendment by amendment, just like constitutional amendments to the Florida Constitution. You won't see 20 amendments all together in one question. They are singularly identified and single questions on a countywide ballot out into the future. So amendments in the future tend to get a lot of community focus because they are single issues. And so amendments in the future also generate a lot of community conversation because you're generally only talking about 1, 2, 3, maybe 4 issues in any given cycle of amendment changes. And so they get a lot of attention out into the future. So what are some of the hot topics right now? and charter counties around the state. So I mentioned legislative classifications. Obviously, we are negotiating on a lot of preemptions right now with the Florida legislature for cities and counties around the state of Florida. This is not unique to Florida. Preemptions are on the rise in many states around the country. The academics have identified a whole host of reasons for that, not the least of which is the global economy, and not the least of which wanting to compete with each other, even as states. You all might remember when Rick Scott became governor, and he challenged then the governor of Texas to say, I'm coming after your businesses. And so that wasn't just a one-on-one between two elected statewide officials. This is something that is going on all around the state where states are competing with each other for businesses. And so things like uniformity in regulations, having only one regulatory scheme that a particular industry sector needs to comply with, helps that competition because it streamlines their ability to come into the state. And so lots of healthy debates about the pros and the cons and the unintended consequences of that, but also going on all around the country. So legislative classifications in charter and non-charter counties. Preemptions, special acts. We are seeing a rise in the number of special acts with respect to seeking reform at the county commission and at the county government level that we hadn't seen in quite a while. And so we're finding special acts now that are seeking to change the districting scheme, for example, of even non-charter counties, of trying to put on the ballot a choice that is different than what the community had already decided. And to say that there have been 2 or 3 doesn't sound like a whole lot, but when you go for 15 years with 0, having 2 or 3 in 2 years is quite a lot. That's a 100% increase, plus. I do words, not math, so it's a lot. County commissioner term limits, obviously, very hot topic all around the state, been a legislative issue now for a number of years running. And then local intergovernmental conflict is not unique to Lake right now, and how you solve community problems as a community when you might have different ideas of what that vision looks like, but you all live, work, and play here together, there can be some conflict there. And yes, we are seeing that also around the state, and that happens with growth. And it happens with diversity of your citizenry, and by that I mean diversity of ideas as well. So those things are happening all across the state of Florida, and those are some of the hot topics that we've got right now. And Madam Chairman, with that, I'll be quiet for this part and see what questions you all might have.
All right.
I'm sure you do.
Yeah. I mean, we can jump right into questions. Does anybody need to take like maybe 5-minute break and then we'll get into the questions? Can we do that? Like,
Let's go for a break.
okay.
That means let's go for a
Just
break.
short break, about 5 minutes, and then we'll start back with questions. Okay, we're back in session, and we're going to let board ask a few questions, if we've got questions, and then we'll open up the floor. We've got a couple speaker cards. So I'll ask the commissioner to my left.
All right, thank you. Just one question. And first, Ginger, thank you very much for the presentation. I'm just wondering, are you going to offer CEUs for attorneys and planners now? Engineers too, I guess.
If the Florida bar says that I can.
Okay, yeah, that was very informative for those that are in the audience that don't typically listen to commission meetings. It was very good sort of nuts and bolts about the Constitution and what's going on. So thank you very much. I appreciate it. I feel much more informed now. My quick question, I think, is regarding one of the options, bringing the charter forward. You mentioned 15% of the voters. Yeah, could you just touch on that a little bit more? Does the SOE, Supervisor of Elections, receive some kind of like a petition that is verified through the SOE, and then it basically just says, okay, here it is. It's now you have to put it on the ballot?
Yes, there are some, well, no. So there are some provisions in Chapter 125 that govern a initial charter review process that comes through a citizen initiative petition drive. So what happens is the petition is not for the entirety of the language of the charter. The petition is for the establishment of a charter review commission. And then the commission gets established, and then the work product finally of the commission is what ends up on the ballot.
Okay. And now,
Do you understand the difference? Okay.
Yeah, I'm glad. That was not what I was thinking, but you just clarified it.
Right, so it isn't like a petition gatherer that you might see. I'm assuming what you're thinking about is like a constitutional amendment where you're actually putting your signature on the proposed constitutional language. This petition is for the establishment of a charter review commission, and the commission then does the work and the ultimate work product. And there's even a whole series of public hearings that have to be held. There is timing. I mean, I mentioned 18 months, but that's from start to finish. You all have 30 days once that threshold of the petitions gets hit, so that 15%. You all then, meaning as the county commission, you have only 30 days to appoint the commission. The commission then has a timeline of when it has to get started. There are even statutory provisions that lay out how the expenses of the Charter Review Commission flow. All of that detail is in there. So all of that happens after that 15% threshold is met by the citizen petition drive to create the commission.
And is it determined at that time how often the Charter Review Committee has to meet afterwards, going forward?
No. So that would be it should be in the charter itself that goes on the ballot.
All right.
I had a question. Because growth issues are so prevalent right now, and you mentioned special act provisions and amendments to the charter. So I could see a scenario where everybody's upset, there's so much growth, let's just stop. Let's stop everything. Let's adopt a moratorium. Or let's prevent people from using the zoning or the land use that they have on the county comp plan. Does the Constitution still govern what a special act can and can't do as far as taking away someone's property rights?
Yes, Madam Chair. So there is a lot that as you've seen, there's a lot now that becomes available to a charter county, but just because you're a charter county, the Constitution isn't washed away, either the U.S. or the Florida, or frankly, for that matter, state law. So a charter county still cannot enact an ordinance that is in conflict with a general law of the legislature, number one. You cannot enact an ordinance or a policy or a resolution that would conflict with the Florida Constitution or the U.S. Constitution. among a whole host of other things.
Okay,
So
so-
all of that is, yes, that is all completely still in play, and is in fact the guardrails for the choices that can be made going out into the future.
So that would apply with regard to like the Burt-Harris Act, we're all familiar with that?
Burt-Harris Act still going to apply.
Okay,
1,000%, yes.
all right.
Yes.
Yes, on a follow-up? Uh-huh.
Yeah, just so I'm making sure I understand what you just said. So all the entitlements that have been granted to date would stay entitlements to date even after the charter county has been established?
Madam Chair, that's a little different question. And I don't know. I am old enough to be able to tell you when I don't know the answer, and that is a very specific question going out into the future that is going to depend on what the changes in the future actually are, which, and I'm assuming you're meaning vested rights. What vested rights are you talking about? And then, Melanie, watch out, because I'm going to punt to you, and that would be a question for your county attorney going forward.
Okay, thank you.
Chairman, I'd like to follow up on that. You mentioned city ordinances over county ordinances or county ordinance over city ordinance. Who sets those up?
Madam Chair, the charter will choose whether county ordinances will trump, for lack of a better term, a municipal ordinance that is in conflict, or if a municipal ordinance will trump a county ordinance, which is the world as it exists in Lake County today, or if your citizens want to just pick specific areas and talk about those. And then you make a choice about the remainder, whether it's municipal or county. One of the resources that I would like to offer up to you all is actually on our website, so at flcounties.com. We have, and I've got it here today. I can leave it with Jennifer or Melanie if you want to go ahead and make copies of it. It is 30-plus pages of a spreadsheet that compares and contrasts all of the charters around the state.
What they don't do.
Yeah. And if you look in the back, there's a whole section on intergovernmental relations, and you will see the variety of choices that have been made by charters on which of these ordinances will prevail. One of the things that I did want to mention to you all, too, in this space is that there are counties in the state that have actually chosen kind of I would call it a conflict resolution mechanism to be embodied in their charter when it comes to certain growth management issues. Now, they're obviously more urbanized than you, but Broward County, for example, has in its charter a commission that was established by the charter that deals with certain conflicts in growth management decision-making that has municipal officials and county officials that sit on that commission. And that commission is actually created in the charter. And so there are certain circumstances when it comes to growth management in Broward where they've got 30-plus municipalities that there's a whole pot of subject matter areas that the community believes isn't just a us versus them, but actually requires a more deliberative process. And it's a little wonky. I mean, it adds some extra steps to things, but it does allow for a more focused conversation on very discrete topics under the umbrella of growth management in a way that is a joint community conversation, and that's embodied in the charter. So there are 30 some odd pages of choices that you can make, and not just in that intergovernmental relations area, but in all of the other topics that we've talked about as well. There's a whole host of them.
Okay, so let's just say, you described those avenues that could result in a vote going to the electorate. And let's say the county commission decided, well, we'd like to actually start with an ordinance and present that. The county commission could limit the subject matter to, say, 2 topics. I mean, it could be that basic, right?
If the charter proposal that goes on the ballot originates with an ordinance, then yes, you would have greater opportunity on the drafting of the ultimate charter.
Okay, so for example, like we talked about earlier, if the county said, you know, our comprehensive plan has rural and rural transition areas on our future land use map. Any decision by a city to annex property would require an interlocal agreement between the city and the county. Otherwise, the density could not be exceeded if that property was annexed. It could be like that specific.
Yes, and. So, yes, in the area of intergovernmental relations, it could be that specific. Your charter, however, is going to have other provisions in it.
That have to be addressed.
Yes, and then the other thing that I would say specifically, and this is something that we didn't talk about, but there are, just by being a charter county, even without that level of discrete language, in the areas of annexation, for example, in the areas of community development agencies, so CRAs, there are some statutory provisions that automatically kick in with some different tools for you as a charter county that exist just by operation of statute that don't even have to be in your charter.
Okay. Now, back to that ordinance idea. Can you establish a threshold for making future amendments?
Yes. Within certain constitutional boundaries, yes. You can't make it zero. And I'm just saying, like, there have to be certain constitutional thresholds that are met, but I can't tell you what those numbers are.
Okay, because what I was concerned about was some of the discussion about, you know, additional tax levies and
Right.
things that could be available.
Right.
And wanting to give the public assurance that the purpose of this discussion and, you know, potentially an adoption of an ordinance were not done for the purpose of, you know, utilizing those additional tax opportunities, so that you could even state that in order for them to be imposed, there would have to be, you know, I don't know, 75, 80% vote of the electorate.
Possibly, yes. So there are going to be, again, because the statutory scheme and the general law in certain areas is going to always prevail, whatever charter choices you have made. So in the area of taxation, we have all been expressly preempted by the state whenever it comes to taxes, for example. So we can't do any, you can't impose any local option sales tax without following exactly the statutory scheme that has been laid out. So there are times when, even when what you're seeking is to limit your authority, that if challenged, someone might be able to successfully argue that what you have placed in the charter is in conflict with the statutory scheme.
Okay.
And so each of those issues it would require a really thorough legal analysis before you did it. And I realize I'm a lawyer, and I realize that's a lawyer answer, but it is just the truth in terms of you would really need to take those issue by issue and so there's a space where you can limit, and then there's a space where you can't. Mm-hmm. What those boundaries are, I can't tell you right now. So we've got some counties that have been challenged and lost on limitations, and some counties that have been challenged and won on charter limitations. So,
Okay, Commissioner Parker.
Yeah, I guess, so similar question I was going to ask is, you know, again, just trying to get my hands around all this. Is there really such thing as a limited charter? I mean, is it going to be, at some point in the process, will it be set up where changes could come, maybe that might be completely different than stuff we're talking about now in this room, or through the next couple months? And I think you were starting to touch on it with the previous answer, and, you know, the previous question. But another part to that was, I was thinking, you know, we can do some things now countywide, like a countywide ordinance. So what's the difference between what we can do now versus, is there some kind of constitutional limit then where we can do something county line? I'm trying to think of some kind of prohibition. I'm not sure if we've done that. Maybe internet gambling might have been one. well, no, because that's in the city still, but something like that, I know that we could do now countywide. But what's the difference between that, what we can do now, versus what might go into the charter?
So the difference is going to be the potential for, I would call it legal conflict and not just community conflict. So there are spaces where the courts have told us in Florida that as a non-charter county that you have certain countywide authorization, depending on the subject matter, depending on the way the ordinances are drafted, and depending on municipal action. So one example is for years, whenever it came to the original days of impact fees, when there wasn't a statutory scheme that related to impact fees at all. It was purely a home rule revenue source to help fund capital costs of growth. We had city and county conflict over county-wide transportation impact fees because the county roads don't stop at the municipal boundaries. And there were municipalities in non-charter counties that said, no, we're not collecting them inside the municipality. And the court said, no, you're just trying to, it's not a valid municipal purpose to say we're not going to collect for the county transportation system that is actually coming through your municipality. And so it can just be a very discrete legal issue. And so while I glossed over it, I will emphasize this, that whenever I said those counties that were successful in a ordinance being the original way that the charter was approved, it took time and a lot of legal examination and community examination. And so while the county commission, because it was an ordinance, did have a lot of control over the drafting, that didn't mean that the drafting was in a vacuum. And it actually can take longer because you do have more time. You don't have that 18-month constraint if what you're looking at is an ordinance. And you will still want the same level of legal review that you would have in a charter review commission for a lot of the discrete issues. And the other thing that I would say is you will find provisions in other county charters that if they were to be challenged, might not come out victorious at the other end. That doesn't mean they didn't end up in the charter, and that doesn't mean that they didn't get voted on. But so far, the choice is still very reflective of the community, but that could change in any given just election cycle or as we continue to grow and the diversity of ideas in our communities change. So there are some provisions that are out there that probably, and there's some that aren't even, that are not enforced anymore at the county level because they know that. Even though it's still words on a page, they recognize that the courts have changed, and this is probably something that we can't even enforce any longer.
So that's the point where you're saying it takes a long time because if somebody's not happy, they may challenge it, and if there's a weakness there.
No, I'm just saying to make sure that you have time for the thorough legal examination and a thorough community conversation. That's all I'm saying. Yeah. But I'm just saying that when you look at this, you're going to see things that are still in here from 10 years ago, 20 years ago, just because they haven't been removed from a charter, but have been found to be unconstitutional. So you need time to also know.
So not everything on that list is a good idea.
Not necessarily copacetic. Yes, correct. It just is. These are words on a page in some other county, but is not an endorsement that it's all okay.
I just have a couple of questions, and one of them you may not be able to answer at all, is in your travels through the Florida Association of Counties, when you see these counties become a charter county, is the main reason, is there a specific main reason why these counties who are non-charter become charter? Have you seen a correlation there?
Only as trends in certain pockets of time. And so what I mean by that is certainly as your population grows, as the diversity of ideas in your community expands, you have different viewpoints coming into play. So population is one, and the first wave of the charters was very much in the urbanized areas, the highly urbanized areas of the state. You see a strain of them that was municipal county vision and wanting to have one vision for the entire county, no matter how many municipalities were in that county. And then at one time, there was a desire to, in fact, change the duties and functions of the constitutional officers. And then the fourth bucket I would put is very much citizen-driven issues of county commission reform issues. Columbia County, small rural county, in the northern part of the state, petition drive, Charter Review Commission, charter that went on the ballot. They really wanted to deal with two things: salary caps for county commissioners and term limits. And that was it.
Well, and if you look at the years that these came on as charters, we had a Democratic legislature. It was all driven from above, I believe, to get a lot of this done. I'm still trying to figure out how Alachua County, I'm sorry, I stepped on you, didn't I?
Yeah, I wasn't finished, but that's okay.
Go ahead, no, go ahead, I guess. I'm trying to figure out, well, let's take Osceola County. They're no utility provider at all, and they have a charter of government. How in the world does that function?
I don't have a good answer for that.
I mean, we have nothing to sell in Lake County. I mean, they have nothing to sell, but they're growing in leaps and bounds. Anyway, go ahead. My concern was how we're going to communicate with the cities and the people that are providing municipality, the water, the sewer. That's a concern. Sorry, Kirby.
So that's okay.
I'm new. I can do that, right?
I don't mind.
I can't do it next
I don't
meeting, though.
mind. Going back to the causes of the growth of the request for a charter county, I think it's quite obvious for our county is growth and some of the things that I think that we can handle. We try to do it through the state, but I think we can handle ourselves. But what concerns me is that city ordinances have a they prevail over a county charter. So even if we become a county charter, that still may not even be able to help us then, correct?
It depends on the choice that you make in the charter.
Okay, so it
So
depends
you
on the
could
choice you make.
choose, you can choose the opposite in the charter itself. You could choose for county ordinances to prevail over municipal ones, or you could pick subject matter areas and allow municipal ordinances to still trump yours in certain areas.
And then could we also, as the chairwoman said, could we have in that ordinance where if a city has identified a place within the county, they're providing utilities, that they at least communicate with the county commission to make sure it's a good fit for everybody involved? Because what we're finding is some of our county citizens that live right next to a city have no voice in what happens in their community. So I'm just wondering if that's possible.
There are some possibilities that exist with respect to then community engagement on the expansion of services, not so much from and I'm just going to speak plainly, not so much from a county controlling the expansion of municipal services, but there may be some other tools that are available to you as a charter county that come into play in that entire discussion that you may not even get to that point. So there are some other things that might come into play before you even get there.
And then another big one, and I don't know this at all. We have several of our cities that have CRAs, community revitalization areas. If we become a charter county, does that get rid of that, or does that stay in place?
Yeah, Madam Chair, it does not get rid of the CRA. It stays in place, but there are mechanisms then statutorily if you became a charter county on the expansion of those CRAs into the future. It doesn't mean that they can't, but there are some additional administrative hoops that then the CRA and / municipality would have to jump through just by virtue of your being a charter county now. Similarly, there are some provisions related to annexation, and that was the discussion the chairman and I were having off the bat there.
So it doesn't restrict a municipality to truly go into a blighted area and create a CRA?
No.
Okay, thank you.
I want to explore something you said, Commissioner Morris, because I didn't quite understand it. Because Osceola County doesn't have a utility system, and Lake County doesn't have a utility system.
I was just trying to figure out how they operate, and because they're still building. They got the highest impact fees. They're still building, and I'm just trying to figure out how they all get along down there. Do they have an outside municipality or a provider that does all of Osceola County, or is it in different sections?
Well, it sounds kind of like they have the opposite scenario that we have, in that they're promoting growth in Osceola County, like wherever it wants to go. They're okay with that. That's kind of what it sounds like to me right now, without, researching it a little bit more. But from our standpoint, we're like trying to contract and say, okay, we have these rural areas.
Right.
We really don't want to have high density in those areas. So
That's where you come in with the smart growth with infill. But if a municipality has invested their time and money to provide the services, and then they are, you say they can do 3 units per acre, and they can't function without doing 5 units per acre, we're inhibiting them from making any profitability at all to take care of the system. That's what worries me.
which, yeah, I mean, it's an interesting discussion, because is that what, our job is to assure the profitability of a municipal utility system?
Water and sewer is pretty doggone important.
I got just real quick, Osceola, because I'm going to not defend Osceola, to be clear, but I do have some friends there. I know a little bit about what's going on. And keep in mind, they have like half of Disney, so it's a little different situation. Huge economic driver for them. They only have 2, maybe 3 cities. I don't know if Holopole is a city, but Kissimmee and St. Cloud. So a lot of that growth is the pro-growth, but it's directed around those cities. If you divide that county north and south, the south part of that county, and I think it's the biggest land-wise county in the state of Florida, believe it or not, might be Palm Beach County, but it's huge. Most of that below that is just beautifully, I will say, out in the middle of nowhere, and will never be impacted, probably, hopefully never. A lot of state lands, some federal lands that are down there. So it's a little bit of a different situation, but just thought you would know. And they're very similar. They don't have a utility. And I'm not sure the extent of their charter, even what it does, is pretty limited, right? Yeah, I mean, I didn't even know that they were until,
That's what, and really, it is a living document, because
Yeah.
I went through all this, and it just keeps getting added to. And I'm not concerned about us doing this. I'm concerned about 20 years down the road, what's going to happen.
No, and I think that's a big question. But who's to say that in the next year, there won't be a petition that's gathered by 15% of the residents in Lake County, and what comes forward is a request for a charter committee to be set up, and then the time starts, and then you've got your 18 months, and then you're actually not the one that's trying to help guide that discussion. You're reacting as opposed to trying to be a part of the solution up front. And I think that's why this whole discussion got started, and that's why I was willing to even open the door. I want to clarify something I said, because I certainly don't want cities to think that I don't want their municipal utility systems to be profitable in the sense that it is a business that they operate. It has to be profitable. But the idea that they have to expand their utility lines and build water plants and sewer plants, you know, out into the Wekiva Protection Area or the Green Swamp or, you know, the even large parts of the Ilaha Apopka Rural Protection Area in order to be profitable just isn't, that's just not the case. They can be profitable and without annexing all of those places. Otherwise,
It's a good discussion to have with them. I mean, show us the numbers, and what do you need, and where do you need to be? That's what I've wanted, 14 municipalities to come in and talk to us, and let's get a growth statement together. Where can we grow, where we can't?
and then there's the road infrastructure side to this, I think is the other really big part of this equation, is actually getting together and looking at not just the MPO, you know, 5, 10, 20, 30-year plan, but figuring out the improvements that need to be done, that needed to be done 5, 10 years ago that weren't able to be funded, that now we're behind the 8 ball, and we've got more needs coming online. That, I think, is really what brought us to this point.
Well, I mean, it is slowing down with the report we got from a property appraiser. New home starts are down 24.5%. So it's this past year. So it's working. 24.5% less than what we had the year prior.
It's still very, very high.
I didn't say it wasn't. I'm just saying that it's going backwards.
And
Here to there.
And we're in a deficit when it comes to the infrastructure needs. I mean, we're already behind. It's not like we're caught up and now things are slowing down. Okay, good, we get a breather. It's we're behind, and great, we get a breather. That's good, but we've got so much to
We've got a
catch
plan.
up on.
Everybody's got a plan together.
Yeah, definitely.
Well, okay, so let's go ahead and get our speaker cards that we have, and then we'll start to wrap things up. We have, first card I've got is James Homich, and James is he's the mayor of Mount Dora. Thank you for being here today.
Oh, sure. Obviously, this is of interest to the municipalities, so I do want to say that the idea that this got started probably has 100% support from the city of Mount Dora, which is that we do not want to convert agricultural land or preservation land or anything like that that's currently zoned agriculture and zoned agriculture under the future land use map. That should never be touched. I mean, if we stick to just the future land use map that the county already has, that all the cities already have, including, I won't throw any city under the bus. But there are future land use maps sitting out there that have vested rights. And we don't have the money to buy them back. Mm-hmm. So what I'm saying is that the charter amendment, I get worried. I mean, we just passed a $35 million, we're doing a $35 million sewer plant increase. We already have 4,500 units committed to that increase, leaving us 4,500 units, which if you just infill Mount Dora, those 4,500 units are gone. So where can we expand? But anyway, we're all under those auspices. And, but I really don't think, where the charter amendment, where it takes over how we regulate. And I didn't know, I wanted to ask the question. They talk about the ordinances prevailing or the city prevailing. That's interesting, but I was also curious about the comprehensive plans. Is that included? I don't know.
I can ask the question, so.
I mean, but are the comprehensive plans, is one prevailing over another? And then you get into other areas. I don't know that answer. I'm not an expert on charter counties, but I'm certainly hope that And my hope would be that the cities and the county can all come together and at least say, no more changes. There's enough land out there to build for the next 20 years, already committed to the future land use maps. I mean, that's the reason we set up the JPA back in 2004 with the county. That JPA covered the 1992 future land use amendments that extended suburban expansion all the way out past Round Lake Road in Mount Dora. So that's where we drew the lines. I actually wanted to extend it out because that was the time when the county was approving changes to rural lands. Kind of, I grew up, my mom owns a house on the south shore of Lake Dora, 1970. I'm not a native, but we've been here a while. Squirrel Point was annexed, was a county development. Deer Island was a county development. Now across the street, there's a Tavares development. So I've seen it everywhere, but if we just stick to the future land use map, and I know we have the JPA coming up meeting, and the idea if all the cities and counties can get on board with just locking in the future land use maps that they already have, not changing them, I think that would solve all the problems without too many worries with charter amendment or charter county or whatever. But you don't want to take over the what's on the city agendas on a regular basis and try to regulate all the cities in the county. I mean, Mount Dora is a little different from Tavares. Terry's different than Eustis. So anyway, I wouldn't want to take on that challenge. Thank you.
Good points, though, about if the city land use plans and comp plans and the county comp plan was adhered to, then we wouldn't have conflicts. But as far as the question goes, if there was the charter would, in this instance, establish whose future land use map would control. I would think that could be addressed in the charter, just like you could address, whose ordinances control if it came down to that.
Yeah, and a comp plan is always going to be required, whether it's 1 or 15. Yeah.
Yeah, but as far as like whose future land use map controls,
I can't give you a blanket legal answer on which is going to control. What I can tell you, and the way I would phrase it for now, and then say this would be an issue that you would want to take a deep dive into, is the Constitution speaks in terms of ordinances. And so to the extent that there's an ordinance, regardless of what the subject matter is of the ordinance, that's what the Constitution speaks to. And whenever you get off of that, then you need a very detailed legal analysis.
Yeah, and I know like all of our comp plans and LDRs, we adopt them by ordinance, so it probably fits, but that's something, like you said, we'd have to really delve into that.
Do not conflict with 163, the Growth Management Act, right?
Right.
Yeah.
And I think, an intergovernmental coordination requirement would be, paramount, because it would give you those opportunities where there may be reasons to make a change, but you create thresholds and make sure that there's, everybody's in agreement that it needs to be done. Okay, all right, next card, Debbie. Dwayne.
My name's Debbie Dwayne, and thank you for coming to the City of Leesburg meeting, because I was there. And City of Leesburg, not to offend anybody, but totally disregarded anything residents had to say. So I live in Rural Highlands, which butts up right to Highway 27, along with Plantation, Legacy. And to say there is not a traffic problem in Lake County is just so much a deniability by the city, the county, the state. There's so many accidents on Highway 27 that 27 is now the deadliest highway in the United States, not Florida, but in the United States. My property backs up to agricultural land, which somebody just put a PUD in, and they want to put 4,998 dwelling units on 857 acres of land. If you've ever been down to Villa City Road cannot accommodate all that traffic. The abundance of wildlife that is not even mentioned at all. Where are these poor animals supposed to go? I have gopher turtles, foxes, coyotes, and they're all, in fact, there's one developer that admitted to smothering gopher turtles in lieu of, he'd rather pay a fine instead of having these gopher turtles. And if that happens on my property, I'll have the EPA out there, you can bet. And water shortage. There's actually ocean water invading wells now in Florida that nothing's being done about. If we're all on water restrictions, why are we even talking about building? I can only water 2 days a week in my subdivision. How can we build more? Nobody can answer that question as far as where's everybody getting the water from when there is no water? It's going away. So, and to improve the water, it's going to cost $1.7 billion to invest in critical water projects that we need. So I feel sorry for Mr. Conley that his moratorium didn't go through, because that's what we need right now is a moratorium on building. Thank you.
So we have one more card, and that's Kathy Haviland.
Hello, I'm Kathy, and I know most of you from the Elder Affairs Coordinating Council. I represent District 5. I really was instructed to write if I might want to speak, and I didn't have an intent to speak. All I knew was this morning's news said Lake County and development, and it concerned me. I'm very fearful. I live in the unincorporated Fruitland Park area right by Lake Ella and Rolling Acres Road, where Lake County is seeming, and Lady Lake is seeming to approve everything. And when you say, you know, building and there's not a whole lot and it's down 24%, miles and miles and miles of homes and businesses are going to happen right on Rolling Acres Road. Very scary, very scary. So I would hope that being a charter county would help the county regulate and maybe put a little bit of a hold on some of this development that's happening out there. Talk about fatalities and accidents and et cetera, et cetera. I have squatters living in the woods. I'm calling the police. Lady Lake police show up because they get there quicker. So there's a lot of issues. I'm almost 25 years living on a 10-acre tract. Most of us, there's only about 5 of us back there. So every day I'm being, promoted. Developers from New York want my property. Every day, text messages, emails, they must have access to the tax roll. So very concerned, and I'm glad to be heard. And behind Leslie, it says Real Florida. When I moved here 25 years ago, what about the next Real Florida 25 years from now?
Thank you. Appreciate it, Kathy. Appreciate all you do. Okay, well, those were the only cards that we had for public comment. Online, let me check. Okay, we've got somebody.
Yes, Mike Trainer. You should be able to unmute your mic, and please state your name and then give your comments to the board. Mike, you'll need to unmute your microphone.
Maybe he gave up. No. Is there anybody else online? That's our only online. Okay. All right. And I do want to let you know that we have the survey online, and it's you can find it on our web page, but it's www.lakecountyfl.gov/growth, and you can go online and you can take the survey. You can also, if you have specific questions from today, but you didn't want to get up and ask them, or you think of them later, you can send an email into our portal that's on our webpage for citizen comment. So we can get those and we can compile any questions that we receive, and then we can confer with our expert and maybe get those questions answered as we go forward and have additional discussions over the next month. So any other questions before we wrap up for the day?
No questions. I just want to say thank you for coming down to educate us a little bit, and thank you for the citizens of Lake County for being here and participating.
Absolutely. Thank y'all.
Yes,
Chair,
Mr. Parks.
I also want to thank Ginger, huge fan of FAC, Florida Association of Counties, the ICG that she mentioned. Remember, that is UF, IFAS based. We are totally blessed in the state of Florida to have IFAS, UF IFAS be a partner with FAC, where they can provide us science-based, fact-based information to help us enact policy. So thank you very much. Other than that, it's at the risk of sounding like a cheerleader today. Thank you, cities, for showing up. Thank you, all the residents that showed up. We can do this. We can absolutely do this. In the next 6 months, by the end of this year, we can actually do this and make these decisions and be better off starting January 1st, 2026. Now, all the traffic and stuff like that may not go away on January 1st, 2026, but at least we'll know that we've turned the course. So we can do this if people want to, elected officials in particular want to do this, it will get done. So that's the sort of the coin, the challenge that I put out there for all of us, me included, and I just really appreciate the opportunity to learn a little bit more today about Charter County.
And I know that Commissioner Parks has kind of been our leader on joint planning agreements. And I sense that you probably are thinking we probably could do this with joint planning agreements. Wouldn't necessarily have to have a charter.
Well, I mean, I think
Or maybe it's
I
got to
wouldn't
be a
assume that.
combination.
Yeah, respectfully, I wouldn't assume that. I'm in pure listening mode right now. I want to listen to the cities. Yeah, I wish JPAs were done 3 years ago. Being completely honest, we would have been a little further off than a little further along than we are today. But regardless of what happens with this, I hope the outcome is through joint planning agreements where we get these road funding agreements placed out. And I know we're going to get some specifics on that, like actual projects, so that you see if we do this, this is what you get over the next 10 years, and it's accountable. I get the whole thing. I'm optimistic and a little naive sometimes. I think we can get it done in 6 months. If there's a willingness with all the cities in the county to do it, we can get there.
All right. And our next session is, it's growth management. Is this the growth management 101, where we're actually kind of stepping back and we're looking at what the tools are, what?
Correct. So that one is actually, I'm pulling up my calendar to make sure I have the right one. That is actually scheduled for Tuesday, June 10th at 2 o'clock. That's going to be at the Agricultural Center off of Woodley. And that is going to be a joint planning workshop with the Planning and Zoning Committee as well as this board.
Okay.
Could I ask also that possibly we get some listening sessions in the larger areas like Claremont, Leesburg, just set aside an hour at an evening that somebody could, maybe Sean could go there and
I'd be happy to do that.
in Claremont, and he could take their concerns. I could go to Leesburg, take their concerns, because a lot of people can't attend.
No, I think it's a great idea, and I've heard the same feedback, that it's hard during the day for folks to participate, and I love the idea of us doing sort of fanning out around the county and then using that as an opportunity to get feedback and go over a lot of these issues and hear what our residents have to say. June 10th is?
June 10th, it's at 2 p.m. It is at the Agricultural Center off of Woodley. And this is going to be a joint meeting between the Planning and Zoning Board Committee and the Board of County Commissioners. And this will be with our consultant, Kimley Horn, to discuss the kickoff of the comp plan update.
Okay. All right. And so that really focuses on the county comprehensive plan, but, just it's very important.
It's very good information.
Well, it's great information, and it kind of helps put all of this into the context of we have to deal with, like we talked about today, vested rights and entitlements and things like that. We have a comp plan that's been in existence for, 30 years. And so we can't just go and take away land uses that are designated. We have certain, because if we take away land uses from people, we will be sued. And none of us in this county have enough money to defend the lawsuits that would be coming our way. So it's a constitutional issue. It's part of the fabric of America. It's like a zoning map that covers the whole county, and a lot of it for Lake County is rural. Our future land use map is rural and rural transition. Most of our urban expansion in urban areas and urban median areas, they're already surrounded pretty much by the cities. They're enclaves, you know, they're places that are already urbanized. So I just kind of want to put that out there so everybody gets a feel for the fact that the county's comprehensive land map already has a lot of rural and rural transition areas. And I think a lot of what we are trying to bring to the forefront with our cities is how do we go about delineating where municipalities should end and rural should remain intact. You'd have to come up and fill out a card, and you know, we could talk afterwards about that. I'm happy to stick around and we can talk about that more. But as far as this moving forward with the charter discussion, we have to get our comprehensive plan updated because we have to do that by law. But assuming that we're able to work something out through a charter or through an intergovernmental agreement with the cities that will honor our comp plan, this revision is going to be very important because it's going to decide, do we leave those rural areas where they're at right now? What do we change about that? What do we change about our comp plan? So this is really important to get public input because we really need to hear from our residents as far as how that map is going to look going forward. So with that being said, I'll stick around if anybody wants to talk some more after this meeting. And again, thank you so much. And thank you so much, Ginger, for being here. It was a great presentation, really, really informative. And thanks again to our cities. We do really want to work together. We really, really want to work together. We just have to get there. So thanks, everyone.